Today is on our addendums, and everyone make sure down there, download the app on there. You know, one of the most significant things that's happening, and we're going to talk about it a little bit later, is, as you know, there's been a class action lawsuit. I've gone through the 44-page complaint. I'm going to go into that a little bit further. Later, we're going to give you some proposed addendums on that. So our purpose today is to go over all the different addendums. One of the biggest problems is with realtors is that additional term section. All right. So when you get that additional term section, just remember you have a license to sell real estate. You do not have a license to practice law. It's called UPL, unlicensed practice of law. If for some reason the bar would come after you, it's a $50,000 fine and could be 5 years in prison. Brokers down in South Florida do not allow their agents to write anything in those sections. I personally believe that should be the law. I think I fault the bar for, quite frankly, not going after realtors, because you shouldn't be writing. Now, in most states, a lot of states, the realtors don't even fill in the blanks on the contracts. They won't even do that. Florida is very liberal on that. But lawsuits are at an all-time high against realtors. Claims on errors and omission policies are at an all-time high. Some brokers can't even get insurance anymore because they've had too many claims. So be careful. What I always say, stay in your lane. You know, if the client asked you, hey, you know, you've been doing real estate for 20 years. Why don't we go out together and let's do the inspection together? How many of you would say, yeah, I know what I'm doing. I've been doing this for 20 years. How many would do an inspection? Okay. Then why, for God's sakes, do you practice law? So when they say, hey, put a clause in there about appraisals. Yeah, okay, this project's contingent upon appraisals. Stay in your lane. It's very tempting to do it, but don't, because one day you will get in trouble. I had an agent just this week that did some stuff, and they're now writing a check for $5,000 to their client because they messed up on language for the deposit. So we're going to go through all that. I don't mean to scare you, but I do. So just be careful. And you know, one of the things that we do here that's kind of different is we help our agents. We believe that we have 3 attorneys here and another 4 people on our legal staff. If you need help, it's part of the service. So if you need to do an addendum or language, if you're using us, if we're doing the closing on there, we consider that part of the service. You need help on that, we're here to help you. So take advantage of it. Email us. This is the best way to do it. Give us a quick call. A lot of the sample addendums you're going to see are resulting from agents that reached out to us and need something. The most recent one we're going to go over in a little bit is once you look, everyone uses, most of the time we use the as-is contract. And then what happens is you do your inspections, and then we need some stuff done, right? So now what happens is you write it, seller shall repair the sliding glass door. And that's not good. When, how, all this stuff. You're going to see I wrote an addendum for you guys to use that'll set forth everything in there. So what the problem is you guys aren't lawyers and you don't know all the terms, everything that needs to be in there, and protect them. And believe me, when it doesn't go right, who do they point the finger at? Not me. I wasn't involved. You. And who do they want to write a check? You. Who are they going to go and see one of the TV lawyers to go after you? They're going to go after you. So be real careful on that. Unfortunately, we're a litigious society. It's gotten really bad. So let's, before we get into that, one other thing I want to, whoops. Well, I guess it was not going to be on there. Huh? TV slide? Yeah. Oh. Okay. One other thing, we have these little flyers here. In case you don't know, we sponsor a show every week called Real Estate. Where's it up there? Okay. All right. So it's a Real Estate Showcase TV. This is a great way, and we sponsor this show. And one of the things we did with the producers is we made it, and they do this in other markets. They charge realtors because of our sponsorship on it. We do it free to realtors. You can put your listing on here. So it's every Saturday, 12:30 on Channel 27. It's about listings. If you have open houses, put them on there. So just submit them onto orestv.com. We have little flyers here, and it's a great marketing tool for your when you go on a listing to maybe beat out somebody else and say, hey, you know, I'll try to get yours listed on there, especially for open houses. We need some more open houses on there. We're a little bit lacking on there, but it's great exposure. And it's other thing too, to tell your clients, hey, why don't you look at the show? If you see something on there, just let me know, and then I'll make arrangements to show it to you. So it's a great tool. It's a fun show. Besides just the homes on there, we do some lifestyle tips. We do real estate tips, title tips, things like that. Okay, let's get into the meat of the subject. All right, now David, you're gonna flip through all those again. So one of the things too, let me preface too, is a service that we have that takes the burden off of you. So I think we have a flyer in your packet on it. It's our seller, it's our buyer rep program, and it's a great program to do. It's a flat fee of $995. We'll represent the buyer, so they sign up with us. We'll do the contract for you. You don't even have to do the contract. You submit it, then it comes back with changes. We'll go over it with the client. We write any special language in there. Once they get the inspections back, we'll draft the addendums. We'll look over the title. We'll do what's called a title objection letter, get a better policy for them. We'll look over the closing statement. 75% of the time we save them money on it. And then we do everything except we don't go to closing. And the nice thing is they retain us. Then if one of the attorneys are on duty for that weekend, so if you find property on that weekend, just email or call, we prepare the document, send it back to you. So some of you kind of heard this before. I had a client probably about 6 months ago. She's showing property. She calls me. I was on duty that weekend, Saturday, get on the phone. I said, okay, tell me all the details. And she goes, what do I do now? I go, look in your inbox. She goes, what do you mean? Contract's done, as we were talking. And she says, what am I going to do tomorrow? I said, I don't know, go sell some more property. She says, no, when the counter comes in, just give me a call back and then we'll do it. They countered the next day. There was something that changed on there. I said, I'm good with that if the client is, and boom, we're done. Now, let me tell you where else it's good. Just had one this week where the seller, this is a nightmare. Seller used a title company in California. They just got licensed on January 5th. 2019. I looked up the guy who held the license. He just got licensed December 15th. He's located in Pennsylvania. What a nightmare. They charged them $600 in fees that were illegal. They charged them from a CPL fee. Anyone know what that is? Closing protection letter. Under Florida law, we give those to the lenders. And by Florida law, you're not allowed to charge for it. They charge $25 because in California they do. So they charge about $600 in fees. They shouldn't. We got those all wiped off. They also wanted to charge the buyer a notary fee. I said, no, we're not paying a notary fee. Well, we have to send a notary out there. I said, it's not our problem. The contract says that you're going to close it in the county in which the property is located. It's Orange County. I'm sorry that you're in LA. Either you fly out here, if you're a Florida notary, and do it, or you're paying for it. We got that. We can get that taken care of too. So getting represented takes the burden off of you guys, and it's a great way on there to do it. We also have a program for sellers too, that we can represent the seller on that. Okay, so try, everyone log on to your Poll Anywhere. Oh, look at that, everyone already voted. You guys are quick. Good. All right, good. Just want to make sure it's all working. No one liked the SB? No? All right. Okay, so just kind of the, the legal side of us on here. What is the addendum? The definition is it's a contractual modification of an existing contractual obligation. Most of the time, an addendum is used for like extending the closing date. Oh, and by the way, guys, be very, very careful. I just saw another one of these yesterday. Because of technology today, people are on the PDFs are crossing out terms, and you may not notice them. And you need to be real careful because this happened last Wednesday. Someone got an offer on there, and I said to the agent, she happened to send me the contract for something else she had a question on. I said, did you see they crossed a couple of things out on here? One of them was if the seller, right now under the FAR contract, it says if the seller defaults, the buyer can either get their money back and walk on their way or sue the seller for specific performance. On this one, they crossed out that they can sue them for specific performance. So here's the scenario. Your buyer's all ready to move in 3 days before closing. Seller goes, changed our mind. We couldn't find another house. Whatever the reason is. We're canceling. Buyer's panicking. They come to us and say, well, let's sue them for specific performance. I've got contract. Says, no, you can't. Your only remedy is getting your money back. What? How can they do that? Well, guess you didn't read the contract, did you? It's a minefield out there. So another one that said that if the seller, it's in the FAR, part of the thing is you can also get damages. They crossed out damages. So you got to be careful. They sneak things in there, and they also sneak things in paragraph 9A and B where it says who's paying for what. There's that other line that says other, and they're sneaking things in there. I had one the other day, 5,000, the seller would pay 5,000 closing costs. They snuck it in there. And when I was talking to the agent, I said, you know you agreed on the 5,000. She goes, what 5,000? I go, it's in 9. She goes, oh, sneaky. I'm like, it's not sneaky. It's there. So just be careful of that stuff. So it's either doing things like extending the closing date or it's incorporating additional terms, like a buyer's attorney approval, FHA financing, appraisals, things like that. So, all right, time to vote. Addendum, a piece of paper affixed to the contract. It's a contract. It's useless. A contract which modified. Damn, guys are quick. All right, everyone's up. We usually got to get people going and awake by now, but you're all good. All right. Now, it is a piece of paper affixed to a contract. Well, sometimes it's not a piece of paper. It's electronically. All right, so it's a contract which modifies an obligation, existing obligation, or creating one. All right, good. Now, FAR addendums. First of all, the FAR addendums are good, folks. How many people have written in the additional terms something about appraisals? Contract contingent upon appraisal. How many have done that? Y'all have done it. Come on a minute. All right, let me put this straight. How many people have seen it or had the other side do it to you? See? All right, now listen. This is why it's so dangerous when they write, this contract is contingent upon appraisal. Here's the problem. When is it done? Okay, 5 minutes before closing. Hey, sorry, didn't come in appraisal. We're leaving. What happens to it? Do you get a copy of it? All those are unanswered questions. Guys, the two heads are better than one. The Florida Association of Realtors and the Florida Bar have come together, use these addendums. They're good. They are really good. One thing that's bad, on the bottom left-hand corner, FR/BAR, Florida Realtors and the Bar. Okay, if it says on the bottom CRSP, CRISP, remember, who's took my class before? CRISP is? Come on, say it nice and loud. Crap. Come on, we're not bashful here, we're all friends. CRISP is crap. All right, it's garbage. So, the CRISP addendum does not match the FAR contract. It's meant to be used on the CRISP contract, which is crap too. It used to be called the FAR addendum, and then they got rid of it. Now somebody woke up from a bad nightmare and decided to use it again. Why? I don't know. Now I see the FAR contract and the CRISP addendum used, but they're not made to go with each other. That would be like taking a Toyota, No, it'd be like taking a Toyota carburetor and wanting to put it into a Ford Ranger. It won't work. Your car won't work, so don't do it. I had someone that said, Well, that's what my broker insists that we use, that they use the crisp addendum. I go, no, they don't match. So remember, don't use them together. So in addition to the contract, we have these great addendums, and we're going to go through a lot of those. All right, so the first one is the condo rider. It sets whether or not the association has approval of the buyer. So you got to ask. Now, luckily, in the Central Florida area, the vast majority do not require that the association approve the buyer. But there are some. Just had one 2 days ago in Mount Dora. So they had to do it. You've got it. Now remember, what you do is when you take your listing, it's like your interview with your seller. You got to ask. And they may say, oh no. Or they may say, nah. But remember what I've told you guys before, and we're going to go over on here. After you take your listing, always call the property manager and say, I'd like to find out some things. And we'll go over that in a minute, what you should go over. Because it's not that your seller's lying. They sometimes don't know. They don't keep up on things. Better to confirm, and better, again, we always like to be proactive so you have a nice, smooth transaction and you have a smooth closing. One of the problems in today's industry is, and I have a real estate license too, is we treat each other badly. Okay, we have got to elevate the profession. Right now in the standings, you know that realtors rank lower than used car salesmen. You guys are nasty to each other. Stop it. You're professionals. Be nice. Use nice language. I had one the other day. They copied on me. You know what the one agent said to the other? It started out, you need to go to ethics class and learn a few things. Really? Is that the way you're going to start out the email? Wow, that's going to start things. That's going to have the things go well. You know, elevate it, bring it up a level. Before you hit that send button, read it and go, would I like to receive an email like that? Even if they did things really bad, there's no need to start doing that. There's a nice way to do it and elevate it. And you know something, if you do it nicely, the other side's going to appreciate it. And it's just going to help each other out. We've got to help each other out. All right, whether the association's members have the right of first refusal, because that's something. We had a short sale years ago. And by the way, short sales are coming back. They're back. We're going to talk about it a little bit. So we had one a few years ago where we fought for 6 months. We got it done. We got it approved. The association, the agent never contacted the association. All ready to go. Go to the association for the final estoppel. And guess what they said? Oh, we have first right of refusal. We need to put this out to our members. Well, they put it out to their members, and four unit owners wanted to buy this. Well, the buyer was upset, to say the least. They've waited 5 months for this, and then they didn't do it. Now, what do you think happened when 5 unit owners wanted to buy the subject property? How do you determine who gets it? Okay, you got to look at the declaration. In their declaration, it said, if there's anything that multiple, they draw lots. And they literally had a meeting where they put straws and cut one in it, and the short straw won. So, and they got it. They got that unit for $65,000, and that same unit now is selling for about $200,000. So it was a great deal. Don't forget, this was 10 years ago. So make sure they don't have a first right of refusal. Fees, assessment, prorations, litigation. You've got to state whether they're monthly, quarterly, semi-annually, or annually. The seller has at closing, they got to pay all the fines. Seller has, whether the seller has knowledge of any special assessments or any litigation. It's going to fit right in what we're going to talk about later. You live in Avalon, Eastwood, all those ones affected by the plant. There is now pending litigation. It's a class action suit. We're going to go into it. There's been some stuff on the boards about something about opinion. There was one attorney that says, nope, you don't need to disclose this. I want to know, did he read the lawsuit? Because you do need to disclose it. And the other thing too is sometimes people don't know this, especially if it's an investor that's out of state. You know, is there any pending special assessments? You have to also disclose if there's one possibly being discussed. Now, we had one several years ago that it was coming up, and the buyer finds out, and they weren't going to close, and they were like, well, how could you not tell us about this? The seller said, honestly, I didn't know. And the association says, look, we sent a letter out to everyone. It's been in the newsletter. And the seller finally said, you know, I get that stuff in the mail. I never even open it. I throw it away. So they did know, but they did have notice of it, but didn't have knowledge. So that's why, again, you should call the management company and get and verify all the information. Sprinkler system retrofit virtually never comes up in Central Florida. It's mainly in South Florida. Non-developer disclosure, buyers to receive a copy of all documents related to the condominium association. Option A, confirm they got it. Option B is allows for them to terminate. And believe me, and you guys have heard me say this before, I get so many calls of, Barry, get me out of the contract. First thing I do is to get your condo docs. Nope. Okay. Out. Here's another known thing. Let's say your client puts in there the association dues are $100 a month and you don't verify. And it turns out they're $110. Guess what? The buyer can walk away anytime prior to closing. Again, call the association. It's great to do. And that's the biggest thing of getting out of the contract. Now, especially around this time of year, we're going to hold questions and do questions during the question period. So one of the things is, especially this time of year when the annual meetings are coming up, and whether there could be a special assessment, there could be a raise, there could be in the dues, all that. Again, very important to keep up on all of that stuff. Buyer's request for documents, receipt of the documents. Another thing that's a lot of problems is parking and storage units. All right. So there's two ways that those can be conveyed. One is by deed, which I like because then it's all on the public record. We all know what's what. You know, Unit 62, Park North, a condominium, and parking space 62. Then there's no doubt about it, right? So when I did condo conversions for large apartments into condos, I made them all deeded parking and storage spaces. Most of them don't. So for example, the Sanctuary, most of the high rises, Sanctuary, Waverly, 101, they don't. So now what you have to rely on is a book, sometimes physical, sometimes it is electronic, and they keep a record of who's who. Now, what's the problem is some of them don't have very good records. There's one association over on Cayley that it says in the declaration that the boat slips are supposed to be deeded. They're not. And then there's another association said they were supposed to be assigned. We asked for an assignment. They have no records. Well, how are we going to convey this? Well, we don't know. We're not going to do anything about it. So we had to do a workaround. But what happens is if you don't do that assignment, now most title companies won't do them. They don't even think about them. So what happens, and this happened to somebody, they closed. 3 months later, someone came up and said, what are you doing in my parking space? I'm a snowbird. I just came back, get out of my space. Well, the owner said it goes with mine. No, it doesn't. We had it over at Star Tower. Someone in there, she had original MLS showed 2. They bought it, had 2. They rented out the unit for 10 years. And part of renting it is they had to submit the lease for approval to the association. It always showed the 2 parking spaces. Thought everything was fine. Then, as you know, the developer went bankrupt. They had someone else new come in. The new developer said, we're taking that space away. It's not your space. They had no records to prove it was theirs. I told them, let's sue, because I think you've got a history of between the listing and using it for over 10 years and their approval. He didn't want to go through litigation. He had to reduce his purchase price by $20,000 because that's what these spaces were going for, and it was a mess. So we always do an assignment. We take it one step further. We have our own form assignment for these, but what we do is we contact the association and say, do you have a form that you require? Because sometimes you can do the form and they go, this is not acceptable. You have to use our form. One of the ones downtown here, they said you had to use our form. I looked it over and I redlined it and I said, hey, would you mind if we made these changes? And the guy said, yes. And he goes, do you mind if we adopt your changes? Because it makes it clear. And I said, yeah, absolutely, take it and use it. So be very, very careful of those, because these, like especially the downtown towers, those are $20,000, $25,000 a space. Guess what? If later on it turns out it's wrong, guess who they're going to want to write a check? You. So just don't fall into that trap. Inspection and repairs, things are going on in the association you need to know about, and obviously the governance form on these. All right, homeowners association, that's governed by Chapter 720. And again, if you don't provide this, it's void. Now, I've seen some contracts where the agents put this on, and if there's no association, they just put zeros on it or put NA. You don't need to do that. You shouldn't do it. It confuses things. If there's an association, use it. If not, don't. All right, so it discloses that the buyer must become a member of the association, because the law states that a buyer should be informed. It shouldn't be, hey, a surprise later, by the way, you've got to belong. And whether or not there's restrictive covenants, and what they are, because some of them are very little and some of them are a lot. I mean, very, very restrictive. We had one recently where we went to close and association says, well, no, there's a roof issue. Go back to the seller and told them that. She goes, what roof issue? I put a brand new roof on 2 months ago. She went back and said, well, what's the problem with the roof? Oh, she used the wrong color shingles. She's like, what? Yep, you have to get approval for the color of the shingles. And she comes back and says, well, that shingle's not available anymore. Association says, yeah, we know. We have a substitute. You should have contacted us. They were going to make her re-roof it. We finally ended up resolving it by, it cost her money. She had to get the color of the shingle approved, go down and get a special paint and paint the shingles to match the right color. And let me tell you, I looked at them. It is nitpicky among nitpicky. I mean, like this, you can see, but if you were on the street, I doubt anyone would notice the difference. But they're like the rules of the rules. I had one recently where it was the president of the association selling his house, and he had some dents in the garage door. wouldn't approve it. The president association tried to get the dents out. They still wouldn't approve it. Finally, they got me involved in it, and I finally called the manager and I said, what is going on here? Do you just not like your president of the association? She goes, nope, we just don't want any problems. They're not going to sign off. We want them to replace the garage door. I'm like, really? He goes, yeah. And finally, what they ended up doing is the seller had to give the buyer a $1,700 credit. We entered into an agreement with the association that the buyer would replace it within 90 days. Because again, we look for solutions to get it closed. A lot of places would be in title companies would go, well, there you go, get it done. We got involved, we drafted the agreement, we got it done, made everyone happy, got it done. Because you know what it is, we'll do whatever it takes to close it, with one caveat. It's got to be legal. All right, it's the only thing. It's fun to get creative on these. Again, you've got to put the obligation to pay how much it is. And again, we got to make sure there's no liens, because those assessments that don't get paid become liens. Fees for common facilities. Again, the other thing too is you got to make sure that there's not an association within an association. Whoa, okay. Now, the other thing you got to remember too is, just don't forget, if you're buying in a subdivision that the developer is in control, they have the unfettered right to change almost anything without the owner's approval. Almost anything. Because some people get upset. They go in there and they go, well, wait a minute. I thought that the minimum, lot size was going to be 1 acre. That's why I bought in here. What do I see now? They're doing a new section with a ½ acre. It's against what the declaration says. They amended it. It's their right to do it. So you got to be careful and don't be surprised on that. Okay, HOA documents in Orange County. What did I do? Okay, in Orange County can be obtained from the clerk of the court, tax collector's office, property appraiser, or the comptroller. They'll slow on the votes now. Working? You're all wrong. In Orange County, the clerk of the court does not record any documents. Change it to D, the comptroller. Okay? Now, Seminole County. Let me just say, all the other counties, you would have been right, the clerk of the court. Orange County has delegated through their charter, which is their constitution, and created an office called the Orange County Comptroller. Phil Diamond is the head of that, and that's where the recordings take place. So if you're ever looking for it, don't go to the clerk's website, you won't find it. Now, Seminole, Osceola, Lake, Brevard, absolutely, go to the clerk's website. All right. Boy, that's... Ooh, okay, wait a minute. So obviously in Seminole and Osceola, we just gave the answer, clerk of the courts, the supreme document overload. What? I think that's from hanging over from the old one. All right, so the clerk of the court. All right, so one other thing on the HOA, COA, be real careful. There's associations within associations. My record of one was down in Sarasota, 9 associations. You say, how can you have 9 associations? They had the golf association, tennis association, pool association, condo association, masters, I can't remember them all, but there was 9 of them. Okay, so again, this is how it works. Ring, ring. Hey, property appraiser. My name is Barry Miller. I'm selling the house. Just got a great listing on 123 Main Street in your subdivision. I'd like to get some information from you. Oh, I can't talk to you. You know, well, you can't talk to me? I can't give you any information. I don't want anything personal about my client, Mrs. Jones here. I just need to get something general. Oh, okay. I want to just confirm the dues are 110 a month. Oh, no, they just went up to 115. Great, thank you very much. Is there any special assessments coming up? Is there any talk of that? It's January. Have you had your budget meeting already and adopted? Nope, that's in a few weeks. Oh, is there a proposal to increase it? Oh, yeah, there is. What's it going to be? Are you within another association? Oh, yes. Well, who do I contact for that? Oh, we take care of that here. We pay, we administer both. Oh, great. Can you take both? So ask all those questions. Any pending litigation? Nope. Are there any liens or anything? This is especially for condos. Any liens against the association? We just had one the other day that there is 17 code enforcement liens, and it's not their building, it's another building, but we still can't close it. We had another one that there was a mechanics lien that they repaired the roof, but that affects all units. So what we did is, in a case of the association, a lot of times if we get an affidavit from the association, it mainly comes up with as a notice of commencement. So what a notice of commencement is, before you can pull your permit and before you can start construction, you have to do a notice of commencement. It says, notice to the world, this work is going on, a replacing roof by ABC contractor. Here's the association, you record it. So for title purposes, we have to get a notice of termination and terminate that, because otherwise the property is subject to a lien. So what happens is, when we get those, we contact the association. If it's like the roof, most of the time we can just take an affidavit that they have enough money set aside to pay for that roof, and we're good. We get it released. Sometimes if we do have an actual lien, we'll get a partial release just as to that unit, so then we can close. So there's a will, there's a way, 99% of the time. By the way, I just read on the news down by Millennia last week, a condo association filed for bankruptcy. Okay, so I can't remember the name of it, but if you run across that, you got to take special circumstances. We have to do extra work on it now. It just got filed, so it's going to have some implications on that. So you got to be careful. So you go through that, get all the information. Now, while you're there, and now that the person who can't tell you anything, now they've softened up, say, hey, by the way, can I just I want to just verify my client's has nothing past due and there's no violations. Sometimes they'll say, yeah, they're good. But the other thing is, you also ask them, are there any violations pending against my unit? Oh yeah, they need to cut the bushes, or they need to do something. At least you can find out then. Again, be proactive. And again, that's the other thing is, as most of you know, um, when you take a listing, right? If you're going to be proactive, do a title search. You know what a title search costs you? Zippo. We'll do them for free for you, all right? That way, again, when you're doing your listing, how much better? Hey, as part of the service we're going to give you is we're going to do a free title search. Hey, I've owned this property for 30 years. There's no problem. Well, we had that with a client. Luckily, we did the title search. They lived in lot 116. There was a mortgage there for Bank of America for someone they've never heard of. What happened is their neighbor down the street at lot 161, they inverted the 116 to 161, refinanced, and they did it. Bank of America. Now, can you imagine finding that out right before closing? Luckily, this agent did it. We saw it. We took care of everything, contacted Bank of America. So she got a contract right away. It was a 45-day close. Worked out perfect. We had the release and all done about 5 days before closing. Again, proactive, get it done. So even if they say, oh, I've owned this, you never know what someone can record against your property. I mean, some people record some crazy things, or they get done by mistake. Or what's more common is we end up doing the search and we found out your client got divorced, and unfortunately, a lot of divorce attorneys don't know how to do deeds, and they did the deed. We had this before. They did the deed. They took the legal, cut and pasted it off the property appraiser's website. Well, it was meets and bounds. Well, it was 12 lines long. You know, the property appraiser only puts the first 3 lines on. So the attorney cut and pasted defective deed. It's no good. So we had to go back to the ex-wife to get her to sign a corrective. You know, the wife told the ex-husband, sure, I'll sign that. $10,000, please. She tried blackmailing him. It's very effective. We said, hell no. And we finally ended up getting it done. But again, we did it at the beginning, so you find out these things up front. And by the way, if you are a notary, you cannot by law prepare deeds. I had one yesterday that the woman had a divorce situation, had her realtor, who was a notary, said, oh, you just need a quitclaim deed. I'll do that for you. Prepared by, did it. It wasn't right. That's the practice of law. Go to jail, go directly to jail. Do not collect $200. It's illegal. It's illegal. Also, just FYI, do you know that a title company cannot prepare a deed? It is illegal unless they are also issuing a title policy, because the law says if it's incidental to the issuance of a title policy, they can do it. But just to do it on their own, by law, they cannot do it. Do they? Yes. But they shouldn't. They really, really shouldn't. Because the problem is if something's wrong, it's hard to go after them, because if it's with the title policy, you can go after their underwriter. All right, so you're going to get all that stuff from your association. You're going to be good. So let me tell you what happened with one of my clients that did this, one of my agents. She did all this. It was great. She gets a call 4 days later from another person in the association and said, hey, I'm thinking about selling my house, and I wanted to set up an appointment to talk with you. And the agent said, oh, wonderful. Did you see my sign in the neighborhood? She goes, no, it's a 300-unit subdivision. I'm way on the other side. She goes, well, how did you find out about me? She says, actually, I was talking with the manager at the association, and she said she was impressed of how thorough you were and getting all the information. She gave me your name, and she got another listing out of it. So again, stepping it up, doing that pays off. All right, seller financing. Again, as the economy turns, seller financing happens more. So a lot of people will just write on the additional terms, seller shall give the buyer a mortgage at 9%. 9%. Okay, great. For how long? What is it? Default, all the terms, right? Don't do it. Use the financing addendum. It'll say the seller will hold the promissory note, first or second position, because sometimes when they write that, seller will hold a note, it doesn't say first or second, and they go get another loan and say, oh no, you're going to be in second place. And then it's a fight because they say, well, I thought I was going to be first. Well, you thought wrong. And then you get a fight. So at least this way, it makes it clear whether it's a first or second. Put the amount, the interest rate, the payment terms. So I've had, believe it or not, some people that said, oh, we don't need a note and mortgage. We have an addendum. We're covered. No, you have to do a note and mortgage. You got to record it, got to pay doc stamp tax, all of that. So you've got to decide whether it's going to be fully amortized. Now, most of the time on seller financing, most sellers are not going to give the buyer a 30-year note. Usually what they'll do is, okay, I'll give you a note. It's always higher than rates. You know, rates are about 5%. Then the going market right now, it's 7 to 10% on a seller financing, depending what's first or second. So what they'll usually do is say, okay, I'm willing to do it for 3 or 5 years. Now, if you amortize it over 3 or 5 years, the payment's going to be outrageous. No one can afford it. So what we do is we'll say, okay, we'll give you a loan for $100,000, 7%. We'll amortize it over 30 years, but it balloons in 3 to 5 years. Now, the law says if you don't do the note and mortgage the correct way, the seller could get zero. Especially on balloon notes, you have to put the right language. So, question, can a title company prepare a note and mortgage? The answer is no. Do most of them do it? Yes. Does that seller want to have someone prepare a negotiable instrument that may be the subject of a foreclosure suit later, and then if they determine it wasn't done right, the seller has not a valid mortgage? Sure, you want to run the risk, do it. Okay, so with us here, the law firm prepares them. We go through all kinds of things. There's something called, we all know, Dodd-Frank. The Dodd-Frank Act came about after the crisis. There's strict requirements on there now that if there's loans given and it's not within Dodd-Frank's requirements, even for private loans, for private ones, not necessarily seller ones, but for private loans, the note is unenforceable. The mortgage could be deemed invalid. So it's so important to get those. And I guarantee you a title company will not know how to do those, that screening and that test to make sure that's right or not. Again, something goes wrong later, they're going to point the finger at you. You told me to use that national law firm. I know you told me they did it for free, but really? Free? Now my $100,000 mortgage is useless? Do you have any insurance? Do you have malpractice insurance? They're going to try to go after you. So kind of be careful on that. Okay. Second mortgage, one of the things too that we make sure that's in there, if someone's giving a second mortgage, is to put a term in there. If they default on the first, that means that it's a default on your second. To me, that's very important, because let's say they keep paying the second but not the first, they're in trouble. I want the right for my client to be able to go after them for that. So there's all kinds of hybrid things going on with that. People get creative financing. We can do all that. There's all kinds of different ways you can get creative. But again, get creative's fine, but let's just make sure it's legal, make sure it's enforceable. So there's different levels of things that are in there. I saw a mortgage that some title company prepared for a client and for the seller, and it didn't even have insurance requirements in it, that they had to maintain insurance, and it didn't have the option in there that if the buyer, my mortgage has in there at the lender, at the lender's option, can require the borrower to escrow the taxes and insurance with the lender. I put that option in there because if, let's say, I tell my clients, look, if there's one time they don't pay that insurance or taxes, invoke that rule and you start collecting them. It's a little bit more work for you, but better safe than sorry. You don't want it not insured. So you've got to make sure you have those fundamental terms in there. Whoops. So things that need to be taken into consideration: grace period, how long are you going to give them? The banks give them 15 days. I don't. I put in there 5 days. Right of repayment in whole or part without penalty, acceleration if they transfer it. Prior liens have to stay in good standing, meaning the first. Prohibit modifications or future advances. Make sure they have insurance provisions and things that the seller wants in there. So there's a lot of things in there. You've got to be really careful. All right, FHA and VA. Again, as the economy turns, there's going to be more and more of this going on. On FHA, the purchaser is not obligated to complete the purchase unless they get their written statement. The purchaser pays all loan expenses except for the tax service fee. Appraisal repairs, the seller gives written warranties or intent to pay some or not. They got that blank in there. Most people put 0 in there. I just had an interesting one. They had in there that the seller is paying up to $5,000 in closing costs, and in that blank, they put $5,000. They put in there, the blank was, the blank said, it says the $5,000 of the closing costs. I don't know what we're going to do if there's a problem because it's very ambiguous. So again, my suggestion is on the seller side, of course, make it 0. If you're using an as is, even on the buyer side, it's fine to be 0 because you have as is. If something comes up, negotiate it and then do an addendum. So you'll be fine on that. VA, same thing on there. There's no costs if they don't go through with it. There's certain fees. The WDO and tax service fees on there, underwriting, doc prep, recording fees. So a seller is obligated to pay some of those fees. The purchase pays any prepayment and escrow fees for taxes, flood and hazard insurance. Right now, as you know, is anyone experiencing their FHA or VA being delayed because of the shutdown? Okay, someone has? Who said yes? Yeah. So you're going to start seeing it. FDA loans are just shut down right now. And we're going to start, if you're not seeing some slowdowns on this. The overall mortgage stuff could come to a standstill if this thing doesn't get resolved, because if the IRS stops sending out verifications, we're done. Huh?
We had one already.
Well, they're not, this IRS isn't shut down yet, but it's slow, huh?
According to what we got in Realtor News, they are.
Okay, well, I think they're slow down. They're not 100%. I've heard they're still giving them, but it's very, very slow because they're on a skeleton crew. But it's just going to get worse. So, and I'm not going to comment on last night. The only thing is, no matter what side you believe in, let's get the government open. I mean, this is just ridiculous. It's ridiculous. Okay, appraisal repairs. Again, if the cost of the repairs exceed the limit, the seller has 3 days to give written notice to the purchaser of the intent to pay some, none, or all. So it's not like it's over with. You can negotiate still. So we can see what it is. And then the option to elect to proceed with the contract. Okay, sometimes it works, sometimes it doesn't. All right, he's in there. All right, this is my favorite one. Use it, folks. Appraisal contingency. It's contingent on the appraisal of the property at the buyer's expense. The buyer shall deliver the appraisal to the seller, if left like 3 days, and written notice. Okay, so the buyer shall deliver the appraisal to the seller, and whether they're terminating it or waiving it. Failure to appraise timely waives it. Okay, so the terms are there. Did we give you that in your packet? The actual F? Okay. Let me borrow yours for a second. This is so important to me. If you're on the seller side and the buyer writes in anything about appraisals, cross it out. Cross it out. Don't accept it. And the buyer agent says, well, I want that. Use addendum F. Okay? Who's got it handy there? Okay, so addendum F. The contract is contingent upon buyer obtaining at buyer's expense a written appraisal from a Florida licensed appraiser. Because by the way, you know when you put in there just saying it's contingent upon appraisal, what happens if you did that contract and it's for 100,000? Barry Miller letterhead. This property is worth 85,000. Yep, we're getting out of the contract. Can we get out of the contract? Absolutely. Absolutely. He's not an appraiser. So what? I did an appraisal. I'm out. But see, if you use this, a licensed Florida appraiser, stating that the appraised value of the property shall be at least blank, if left blank, the purchase price, and honor before a date. Because most people, when they handwrite it in, just say contingent upon appraisal. But when can you do it? Day after closing? All right. If the appraisal states that the appraised value of the property is less than the above value, the buyer shall deliver a copy of the appraisal to the seller within 3 days after the above date. Okay, so that happens a lot. Oh, we had an appraisal for the $500,000 house, it came in at 485. The seller says, let me see it. Nope, not giving it to you. Or they go, you want it? Buy it. I love how they do it. You want it? Buy it. Okay, well here, they're going to give you a copy of it. So that clears up all that confusion. Okay, and then the seller either terminate the contract, and then the deposit gets returned and refunded to the buyer, releasing the buyer and the seller, or the buyer can waive it and remove the contingency and proceed on with the contract, right? And then it says, if the buyer fails to obtain an appraisal, this is what I call the catch-all language. If they fail to timely obtain an appraisal, or having timely obtained the appraisal, such appraisal fails to timely deliver it to the notice of the buyer's exercise of the right, then it's waived. All right, so it's got everything in the magic language is in there. All right, so now when the seller side, or if you're the buyer, you're going to use this. If you're the seller and you get it, you can be nice, cross it out, prepare that for the buyer, send it back with your counteroffer. And if the buyer's agent says, what did you do? What did you do crossing that out? Well, I attached addendum F for you. They'll call you up berserk. They did it and go, look, I attached addendum F for you. Oh, you're welcome. Okay, so just use it that way. So it's just beautiful. And if it was me and I was on that committee for the FAR bar, I would take addendum F and include it in the financing section. My vote would be, let's put it part of it. Let's put it in it. Why not? All right. You thought they were gone. Guess what? They're back. Our short sales, by the way, have doubled over the last 3 or 4 months. All right, folks, we've had 10 years since the Great Recession, aka the recession of, is that supposed to be a signal for me? Oh, it's got the timer up there for me. Right, so listen, we had the Great Recession, which, when history gets really written, it'll go down as not the Great Recession, it is the depression of our generation. Was a depression. They can put magic language, we're all about branding and marketing. You had the Great Recession. That wasn't. It was a depression. It's been 10 years ago. We're due, folks. Everything you do, with questions and question time. So it's coming. Now, is it going to be bad as the Great Recession? No, it's not going to be. There's going to be a correction. Every single economist will tell you that. Well, there's a few of them that won't, but they're out in right field. So, but what's going to happen? All right, so my crystal ball, a lot of people, there's all kinds of things. It's going to happen 19, 20, 21. My thing is it's going to happen in 20. It's going to happen it's going to happen this year. We've already seen it. It usually starts in California, moves. Their prices are already going down in California. There's price reductions, things like that. My prediction, it's going to come, unfortunately, during the selling season here, which is going to be, June. Now, I don't think it's going to be much. I think it's going to be 5 to 12% correction. That's fine. Maybe it needs to be corrected a little bit. Prices have gone up. We're already seeing it now. We're seeing some price reductions. It's okay. But here's the deal. We're going to have short sales again. All right. When it happens, a realtor by law cannot negotiate a short sale. It is the practice of law. Do they do it? Sure. But technically, if you do it, you can't negotiate it, you can facilitate it. Facilitated means garbage in, garbage out. Client, here's the package, fill it out, head back in. Now, if you go, if I'm the realtor, I go, here, let's do it together. I'll write your hardship letter for you. You face that UPL, unlicensed practice of law. Your time's valuable, folks. Don't waste your time. Again, stay in your lane. Don't do the inspection. Don't do the short sale. All right, we got a great short sale program. The only thing it costs the seller is $295. And you'll have title companies, other places say they'll do it for free. What we do is, and first of all, those title companies shouldn't do them. Again, they can't negotiate short sales either. So what we do is we sit down with them. We give them a free consultation. We go over their options. Because a lot of places, they'll go, just file bankruptcy. we've always taken this stance, no, bankruptcy is a last resort. We've done almost 5,000 short sales. But a lot of people that said, I went to a bankruptcy attorney, he said, just file it. I said, yeah, does he do short sales? No. Of course, he's going to tell you whatever's going to put money in his pocket. So what we do is we find out the right solution. First of all, we got to make sure they fit into the right box. Do they qualify? Because let me tell you right now, if they don't qualify and they say, well, I still want to do it, well, then you have to be responsible for our fee. All right, so the way it works is we get $295 up front. That's all they pay. We sit down, we write the hardship letter for them, we negotiate, the attorneys get involved. We've had ones where, we've got to write a nasty attorney letter to get things done, and we'll step in. If they're getting foreclosed, we'll do foreclosure defense. So the foreclosure defense is a flat fee of $495 a month, and we just cover everything. The whole goal of it is to stall off the foreclosure so that we can get the short sale done, you can get your commission, the seller can move on with their lives, and 99% of the time we get the deficiency waived. So it's a really, really good program. It's going to come up more. So instead of wasting your time doing it, do what you do best. Go get some more listings, go do some more buyers, let us do that, and let our team do that. The other thing, when in your pack, we also, addendum G is the short sale addendum. So we have a specialized addendum that you post and you use it instead of G, you post that on the MLS. So the way our program works is they pay the $295, we charge $2,500, and we try to get the bank to pay for it. And I'll be honest with you, the bank most of the time won't. Okay, so I'm still not doing it for $295. So what happens is if the bank won't pay the $2,500, then the buyer pays it. But then we give the buyer a closing credit in there of $2,500. Okay, $2,500 charge minus $2,500 credit means it costs the buyer how much? Zip-boo. I've had so many times where I have to claim, the buyer's agent calls in, Barry, we're not paying that $2,500. We're not going to do it. I'm like, but it's 2,500 minus 2,500, nothing. We're not paying it. 2,500 minus 20 is nothing. Then finally the light goes off. But I'll tell them too, because I'm honest. Sometimes the bank will not allow the $2,500 closing credit. Most of the time they do, but they don't. So I say, look, if it's a real concern of yours, whatever you planned on offering, just offer $2,500 less. And if it turns out you get it for that purchase price and the closing credit, you're a hero. You just saved your client $5,000. So we always try to make it a win-win situation. Short sales are very slow now because in the bank side to get them done because the lenders have cut their short sale departments down, to next to nothing. One major lender, it was so bad, I'm convinced they stall them out because they know they're going to lose their job if they clear them out quickly. We couldn't get one done, and we finally kept saying, finally we went right to the president of the bank. And we contacted them by letter and followed up by phone call saying, and I got pretty nasty with them going, I think you're doing this on purpose. This is ridiculous. We're going to file a complaint with the OCC and with other government authorities. I didn't obviously talk to the president of the bank. We talked to their executive office. It was amazing. 2 days later, I had approval. Yeah. So we'll dig in there. We'll get nasty if we have to. We fight for our clients because we want to get the deal done. All right. So short sales, they're going to be coming back. Again, don't be afraid of them. If you're new in the business before it, don't do them. Don't be tempted to do it. And again, it opens up yourself to liability. I know one agent from the Great Recession that got sued by their seller because they did the short sale. They told them that the deficiency was going to be waived, assured them. Well, they didn't really read everything, and then they got the letter from the collection agency after closing wanting the $212,000, and they're like, no, my realtor told me it was waived. And the realtor goes, yeah, it's always waived. Well, she didn't read it, and it wasn't waived. Big problem. It's just, folks, it's not worth the risk. Okay. I'm not going to go through this stuff because it's all in there. Okay. All right, L. All right, so how many people use, okay, I always call it the regular contract and the as-is contract. How many people use the regular contract? Nobody. All right, let me tell you, if I was a buyer, I would use the regular contract because it has built in there that the seller has to do repairs. They're required to do that. Now, the seller may not accept my contract, but I got a little problem. Is I think you got a problem. You got to explain to your client what the differences are. So, but there's risks involved. So let's say we put on there $10,000 for general repairs, and you do your inspection, and it turns out there's $9,800 in repairs, and your seller goes, and the seller goes, well, yep, we got to go forward. We'll close, and I'm going to make those repairs. And the buyer goes, I have a bad feeling. I think, I don't know, I don't want the house anymore. Can the buyer just say, I got 2 more days on my inspection, cancel? No. Okay, unless you use the superhero addendum, Addendum L. Okay, Addendum L mirrors the inspection clause of the as is, and basically says that buyer shall repair all damages in the inspection contract is terminated or closed does not occur. Buyer may terminate with written notice if not acceptable. If buyer proceeds or fails to terminate, then they don't have to do it. So basically what it is, it mirrors the language that says the buyer, for any reason whatsoever, in the buyer's sole discretion, can cancel the contract. So when your client says, yeah, I got that bad feeling, no problem. I used Addendum L. We're out. We're gone. Okay? So remember, if you use the regular contract, always use Addendum L. It just gives more options, more flexibility. So it's just good to do. And a lot of agents forget this. I had one about a year ago where they used the regular contract and the people wanted to get out of it. And the seller said no. And the agent said, no. You can always get out of the contract. It says in there that they can get out of it during the inspection period. I'm like, no, it does not say that. You're thinking about the as is, not this. They'd lost their deposit and the agent had to write a check because they were misinformed about it. Lead-based paint, don't forget, just before 1978, again, always make sure to use it. All right, so let's do this. Let's take a 10-minute break. Go down here, the food's downstairs, lunch, and the other offices out in the lobbies where you're at. But let's come back up so we can finish everything up. And then we'll go into the lease purchase and lease option. Okay? And if anyone has any way, some people are like, why are you charging $5 for this? The reason why is I'd love to do it for free, but the state of Florida says it would be illegal for me to do so. So we charge you $5. And the only reason we can do that is thanks to sponsors who help us put this on, and hope you guys enjoyed the lunch because it's fabulous. So today we've got Fifth Third, and Shelley's here, and it's Fifth Third's been around for a long time. Yep, and they've been in the Orlando market a long time. So I'm going to let her tell her a little bit about Fifth Third, what they're doing, what kind of programs they have, and how they can help you in your business.
Okay. Thank you. Stick this here. All right. I'm sure everybody here can hear me.
Yes.
Okay. All right. Hello and welcome to all the locations. I'm here at the Orlando location, but I stopped by Altamont, Celebration, Ocoee, and Winter Park yesterday to drop off the same flyers that you have here in Orlando. Thank you for allowing me to sponsor. I'm glad you're enjoying your lunch. And as Barry said, I am Shelley Warticki with Fifth Third Bank, and I do residential mortgages. And we have a lot of the normal products that you're used to, FHA, VA, USDA, all of that. What I did is put a few flyers on your chairs that differentiate what we do. So I'm going to just briefly go over them. I won't take a lot of your time. I'm sure you all have your lenders, and I just want to bring your attention to what we do. So, and the flyers look very similar. This one is, it says customize your home mortgage. So one thing that we do is lot loans. So if you have a client that wants to purchase a lot, a residential lot, and they're not even going to build on it now, they're going to build on it in the future, we can do a lot loan for them. Now, when they're ready to build, 3-5 years down the road or whatever, then we can do the construction to perm. It's a one-time closing up front, it turns into the principal and interest type mortgage once there's a certificate of occupancy. So lot loans, construction to perm. Now, as a bank, we have Community Reinvestment Act money to give away. So if you work with first-time home buyers that may need a little bit of help with the down payment situation, not only will we work with the counties and other entities that give away down payment assistance funds, we also give money away ourselves, up to $3,600. The buyer just needs to either qualify based on their income, or if they're willing to live in a low income area, we'll give them the money. All of it, and it's easy. They just sign a piece of paper saying that yes, we'll take the money. That portion of it anyway. You probably understand how the down payment assistance works if you work with that. Now, one of our premier programs that I love is our doctor dentist program. So if they have a degree and they have a job, even if they're new to being a doctor or being a dentist, we will give them 100% loan to value up to $750,000. So all they pay is closing costs. So I would love to work with your doctor and dentist clients. And something that we can offer, because we're a bank, we have lower rates than a lot of the vendors out there. We want to have a relationship, a banking relationship with the clients. So we offer, and almost everyone that I work with does this, they open a bank account, they get an auto bill pay withdrawal right out of their checking account, and we give them a 0.5 point off their price, the points. If they're a high wealth client and they have $1 million in the bank with us, they'll get a 0.5 point off their rate. And if they have $3 million in the bank with us, they'll get both. An additional 0.5 point off the price and 0.5 point off the rate. So it's really hard to compete with that. We just quoted a loan for a high net worth client that had over $3 million in the bank, 2.75. So that's really, really hard to beat. Another advantage that I have is that I can lend in multiple states. A couple of months ago, I closed a loan in Iowa, for example. We're headquartered in Ohio, so we have a lot of Midwest and Southeastern states. But if you want to know if we lend in another state, let me know, and you want to partner up with someone somewhere else, happy to do that. I'm just going to check and see what else I'm missing. Okay. Lord, I think I have everything, and I would love to work with you. I would be willing to sponsor open houses with you and other co-marketing. We have co-marketing materials that'll put both our pictures and information on there that we can distribute. If you want to work together, I'd be glad to do that. Does anybody have any questions? I didn't quite take 5 to 10 minutes. You're welcome.
We have a question in Altamont.
All right.
We have a question in Altamont.
Oh, okay. I hear a voice.
Yes, hold on.
Where's it coming from?
Hi,
Oh, okay.
my name is Sherry Zorakchu. I have a question. Do you do a NACA program?
NACA. It's not ringing a bell. Can you refresh my memory in case it's
I
something?
think that's for the low income. For the low income, no money down, no closing cost.
It's not ringing a bell. I don't think so.
Okay.
Another organization. Okay. I'm not familiar with it, but I'd be happy to look into it. I don't know all the answers, and I profess that I don't, and I'm happy to check on it if that's something that I need to check on. Oh, okay. Okay. Thank you. Thank you for that. Great question.
I have a question.
Yes.
My name is John, Realty Executives. On your financing of a lot without building right away, how does that work? Can you get into the
How does that work? Like, what are the guidelines around that? Okay.
term?
So it's either going to be a 5-year or a 3-year ARM. They've got to put, if the lot is in Florida, I'm assuming most of the lots that you're talking about would be in Florida. It's 35% down plus closing costs, and they have to have 6 months of reserves payments in the bank. So if that payment is going to be $200 a month, they've got to have $1,200 in the bank after closing to make sure that they can handle 6 months of reserves, if that makes sense. If it's in other states, it's not 35%, it's like 20%, I think. Did that answer your question?
Yes.
Okay. I can't see you, John. I know you're there. Okay. Awesome. Any other questions?
You guys offer offer anything, let's say, if you have a client that's doing a to-be build, some builds say it might be 6 to 8 months build out time. Do you offer any type of extended rate locks?
Yeah, we lock up front because we close up front.
Or up to how long? No, not on a, like if you're doing a to-be build to a builder, not like a final one.
Yeah,
1,000?
for construction to perm, we lock up.
No, not construction.
Oh,
firm,
I'm sorry.
Regular builders.
Oh,
In other words, if you're doing a to-be
We
build.
can extend
let's
the-
say the rate's
we
5
can
now,
extend
6
it.
months from now, it's higher, now might throw the DTI off. Can you offer any type of long-term rate lock for that client?
we can, yeah, we can. Good question. Any other questions before I give the mic back to Barry?
Great. Well, thank you very, very much.
Thank you. All right.
Thank you.
Thanks for having me.
Start to get warm in here. So. All right, back to our regularly scheduled program. All right, David, you can put the slides back up. Yeah, but can you, that's not the right slide. That's kind of at the beginning. What's a contingency?
Let me double check. It should be.
Oh, okay. Oh, okay. I just got this one. All right. So the lease purchase and lease option. All right. This is a contingent on the buyer and seller executing a lease purchase or a lease option agreement within 5 days of the contract. Attorney's fees are to be paid by buyer, seller, or both. If a separate agreement is not executed within the time frame set forth, it's terminated. Okay. How many people like wasting their time? Okay. If you like wasting your time and have nothing to do and want to make it all confusing, then do this and write up the whole contract and do this. This is nothing but an agreement to make an agreement. All right. It's a complete waste of your time and it causes more confusion. How many people in here have drafted a lease purchase or a lease option agreement? Okay. What do you do? You go to jail. Go directly to jail. Do not collect $200. Clearly. Okay. All right. You cannot, absolutely cannot, unequivocally, even every realtor will tell you, you don't. Right? It's really a waste. And you're going to see more and more of these as the economy turns. We make it real easy. We have a one-page sheet. You fill out, you send it to us, we draft it for you. The first part of it is the contract. The second part is the lease. All right, now there's two different things. One is a lease with an option to purchase. So what that says is, I'm going to lease you my house for 1 year. And at month 11, you got to contact me and say, I'm exercising my option and I'm closing at the end of the month, which is at the end of the 12 months. All right. And if you don't want to, you just leave. Everything's good. Right. A lease purchase is, I'm going to let you lease my house for a year, but there's no option. At the end of the 12 months, you will purchase. All right. So that's the big difference between them. A lot of realtors get confused. One gives you an out, one doesn't. Now let's talk about deposits. The deposit generally has got to be substantial. I'm taking my house off the market. I'm risking in a year from now, if the economy turns, I might not be able to sell it. I want $25,000 down. Right? We're working on one right now. It's a $350,000. The guy gave him a $25,000 for lease purchase. And at the end, he couldn't close. I'll see ya. See you later. We keep the 25. Now, does the $25,000 stay in escrow? No. Now, if you're a client of mine, they don't. Why? Hey, you're my client. You want the 25 grand or you want to sit in my account for a year collecting no interest? Why do I put it in your account? It's your money. It's your money. Go buy a boat. Go on that vacation. It's non-refundable. If it's in an escrow account, people can fight about it. Not my account, not in your account. It's in the seller's account. We always put them in the seller's account. I've had one time it was stayed in escrow and it was a huge deal. And the reason why is the purchaser got burned before because he did it and then the seller breached the contract and he was entitled to his money back, but it was rare. So we always put it in your account. We make it substantial. So we want to make sure. Now, on a lease option, do you give the buyer financing contingency? Because at the end of the year, I don't know whether you're going to get financing. Want to give them financing? No. I think once in 10 years I gave somebody a financing. Generally don't. Again, we're doing you a favor. Get your ducks in a row. Usually I have the buyer maintains the property, which is different from a regular lease. Why? I'm letting you stay in my house for a year because you want to buy it. I want to sell it today. How many people have had someone that said, please list my house and I don't want to sell it. I just want to do a lease purchase or lease option. I've never had anybody. So I'm going to give you the privilege of this. So you got to take care of the house for a year. So different terms like that we do there. Again, who pays for the HOA? We got to talk about that. Who pays for closing costs? So this one sheet does it all. It's easy. I'm a big fan of, people in my office know, as I always kid around going, we have the easy button here. Make it the easy button. Just fill out this one page sheet. We'll do it all for you. Cost on it, cost $895 to go back and forth and to negotiate it and get it done. And again, you can decide buyer, seller, or both. One thing I do recommend though is before, and some people kind of look at me like, what are you talking about? Why are you doing that? Generally, I do want the buyer to inspect, by the way, but we don't, I don't like to draw up the contract, have everyone in the money. I mean, it's good. It'd be good for me because I can charge people, but that's not what I'm about. What I like to do is say, look, have your buyer go do the inspections before we draft the contract, because I don't want people spending $895, then inspecting it and then going, no, I don't want the house. It's a waste of everyone's money. Good for me, bad for them. So, but I don't do it that way. What I always say is go do your inspections. If everything's good, then we'll agree on the terms, of course. Then we'll draft the agreement. That way, if the inspection shows something, we can incorporate in there, or even before the lease starts, the seller agrees to fix whatever it is. And then everyone's on an even playing field, get it done up front, and it's a better way to do it. All right, question. Oh, anyone wants to, when is a mobile notary allowed? I don't know what that is. All right, very briefly up until this point, anyone got any kind of questions from out there? We'll. I'm sorry?
When is a mobile notary fee allowed?
Okay. All right. Oh, when's a mobile fee? Okay. Okay. The contract says that the closing shall occur in the county in which the property is located. So, like, for example, when that one that I had was a California company, my opinion, they cannot charge a mobile notary fee because they don't have an office to go to. Because the contract says the closing will be at the office of the title company. They don't have an office. So, oh, we got to use a mobile. Well, then the title company needs to pay for it. Now, if it's here, Orange County, and we have 5 offices, so the person says, I can't go to any of them, or I don't want to, you come to me, then it's proper to charge them. So, yeah.
As long as there's a title office in the county, the property is closed.
Right, right, because it says that the closing shall be at the office of the title company, or a place designated by the title company. So, yes.
Title agent was in Fort Myers?
Yes, Fort Myers.
And they want to charge a fee? Absolutely not.
They wanted to charge fee, and then they wanted us to send a UPS label.
Oh, and pay for the UPS?
Yeah,
UPS
pay
label
for it. And their
to
settlement.
get our commission. And I said, no.
Yeah,
On top
no.
of that, their settlement fee was $750.
$750. Yeah. Hey, listen, down in Miami, Broward, Palm Beach, I see closing fees of $1,300. That's normal down there, folks. Hey, and just a little in there, title searches, right? I have the lowest title search in the state, $55. Most title companies charge $125. I've seen all the way up to $200. $55. We want it to be reasonable. It should be reasonable. The other thing that's a real irk to me is Florida law says title companies can only charge a closing fee, the title search fee, and the title insurance premium. Scanning, UPS, compliance, storage fees, they're all illegal. Illegal. Department of Financial Services said it all needs to be rolled up into the closing fee, because then consumers can compare apples to apples. Because what I get a call is, I'll go, Barry, you're too expensive. What? Your $495 closing fee. Something, National Title Company, they only charge $375. You need to lower it. I'm like, send over what they sent you. They charged you $50 for scanning, $75 for FedEx and copies. I said, when you add up all their junk fees, we're actually less. So you got to be careful. And I had ones that before they go, this happens to me all the time, especially when you do buyer's rep. They go, by the way, if anyone in the remote offices has questions, go ahead and put it on the app right now, and it'll pop right up here. So, what was I talking about? The junk fees. I have it all the time where the other title company will go, well, my underwriter says I can charge that. This happened, swear to God, this happened. It was one of the foreclosure companies over in Tampa after the recession, and they charged $150 scanning fee, and they used Fidelity as their underwriter, and they said, oh yeah, our underwriters has approved this. I said, can you hold on one moment, please? Sure, hold on. I called my connections over at Fidelity and said, hey, this is a situation. Hold on, let me conference you in. Title agent, meet your underwriter. Here's their underwriting counsel. So I want to make sure I have this straight. You just confirmed to me saying that Fidelity National Title told you that it's permissible to charge $150. He goes, yes, sir, that's correct. Fidelity attorney, could you please comment on that? He goes, absolutely not. We do not tell title agents what they can and cannot charge. That's up to you. You can charge whatever you want to charge. So the guy goes, aha, see, I can charge it. He goes, well, let me just finish. The underwriting counsel said, let me finish. However, we can't tell you what to charge and not charge, but Mr. Miller is 100% correct. If you do charge this, you are in violation of state law, and he's allowed to report you. Oh, now will you take it off? Oh, okay. So you got to be careful. All right. We'll have another point for questions too. All right, we talked about TV show. Remember, get to see me on TV. All right, thanks for our sponsor. Come on. All right. All right. The pre-closing agreements. Again, delivery of an agreeable lease. Leases that provide lease shall provide that paragraph in 1112 are no longer applicable. That's the maintenance part. Property in the current condition, sole obligation has to do it. Now, again, the pre and the post, I don't know what is wrong with this thing. All right, David, how would help me out here? The post. Again, this is an agreement. The pre and the post are an agreement to make an agreement. All right. What I always suggest is if you're going to be using these, especially the pre, get it done at the same time so that, and we can prepare these for you. There's a separate cost for doing it, but because again, you can go through the contract and they may say, well, let's wait for inspections or things like that. That's fine, but let's get the terms out there because we don't want to agree. So just remember, a lot of people go, oh, we don't need an agreement. My buyer can move in tomorrow. We used the pre-occupancy addendum, but read it carefully. It says it's an agreement to make an agreement. So realize you do need another agreement attorney drafted. Again, it absolutely 100% a title company cannot draft these. If they're doing it clearly, they're practicing law. So make sure you know that. Sale of the buyer's property. It hasn't been, because the market's been hot, but we're going to start seeing this again as the market slows down. Contingent in sale of the buyer's property. Seller shall get a copy of the contract. Third-party information can be scratched out on it. If the sale doesn't close by a specific date, within 3 calendar days, deliver it to the seller. You can terminate or waive it. So just, again, make sure that you follow these. Backup contracts. A lot of people just, they're afraid. No backup contracts, no backup contracts. Give me one good reason why you shouldn't take a backup contract. I don't think there is one. What is the harm in it? I've got a contract with you to sell my house for $200,000. I may think you're a little shaky. I don't know. She comes along and says, oh, this is my dream house. Oh, I'll do anything. You get 200, I'll give you 220. Tell you what, I'll take a backup contract in case he falls through. No harm, no foul. All right? There's no reason not to do it. Can anyone tell me a reason not to do it? There really isn't. But I have people that insist, we won't do it. You're really doing your client a disservice. And you're making more work for yourself. Think about it. If in case he falls through, what's the old saying? A bird in the hand. You got it there. It's waiting. Put it right on the table. We're done. You don't have to, it's going to save you money, time, everything. All right, so those are good. Kick-out clause. Seller has the right to show the property and enter into a backup contract. Seller will give the buyer a copy of the backup contract. The buyer must make additional deposit. The escrow agent to continue. The buyer can waive the contingencies, and without the deposit, the contract will terminate. Not used a whole lot. Am I a big fan of it? It's okay. I don't see a real big reason for doing it. All right. One of the things we see, again, it's not going to be used as much. A lot of these sample ones we give you in your package. Oh, and by the way, I just was informed, you all use all your addendums and contracts from software companies. I apologize. The ones we have in there are the CR2s. They're on CR5s now. So they're used for reference. I will preface this. It's used for reference purposes only. Use the actual ones for the updated ones, the ones that you have in your software packages. All right. But if you do, let's say you have a client and you know this property is going to go, and you know it's at a great price, and your client wants it, use an escalation addendum. So this just says if they receive competing offers that are equal to or greater than the buyer's office of blank, buyer agrees to pay an additional consideration of blank more than any other third-party offer for a maximum. Again, no harm, no foul. It's a great way for your client. Your client's going to go, wow, you're a smart one, aren't you? I'm glad I chose you. Because this way, it's not a guarantee you're going to get it, but if you know that property is a good one and your clients fall in love, use that. So we got the language in there for that. Buyer's approval and seller's approval, not used a lot these days because, again, the market's so hot. I did have one just yesterday. It's funny. They did the contract and then they had some problems and it fell out and the contract's gone. The agent, the listing agent redid the contract and used the seller's attorney's approval addendum, because in the first contract they had an attorney that was approving it, and on the new one they just put on there that the seller, subject to the seller's attorney's approval, and it's got a blank for the date, and they had 12/17/18. I said, just leave it. It's no good. Sure, because it says if it wasn't by 12/18, this was yesterday, then they can terminate. Well, since it has an old date, there is no seller's approval. Again, bad agent didn't realize what was going on. Oh, I just wanted to use, what's your name? Julia had a great one. She said, wait a minute, I have an addendum. I like using the appraisal addendum. It's a different one than you had. My broker likes me to use it. So we just pulled it up. What was it? It was crisp. She said crap. It was crisp. Now, what we just saw on there, it says subject to the terms in paragraph 3B of the contract. 3B of the FAR contract that she used is not, it creates a conflict. So that's a perfect case of make sure you don't combine them. And like I said, I've had before where that people say, my agent requires me to use it. By the way, your agent cannot require you to do that. It's the seller or the buyer that determine what it is. If you have a seller that says, I don't want to use a FAR, I insist that you use this contract, draft up my attorney, you can't say, my broker said I can't use that. That's a violation of the law. It's a 475 violation. You have an obligation to present all offers. Okay. Trying to figure out, ooh. All right, the financing contingency. All right, you all know that there is a defect. All right. It says, upon buyer obtaining loan approval, buyer shall promptly deliver written notice of such approval to the seller. All right. I have someone new. I'll pick on you. All right. You're the seller. You're the seller. I'm the buyer, agent. Amy, dear Amy, great news. My buyer is approved. Or, dear Amy, pursuant to paragraph 8, let's say I'm a little more far. Dear Amy, pursuant to paragraph 8, this is to inform you that the buyer has obtained loan approval. See you at closing. You good? Amy, you good?
No.
Why not? What do you want? What's wrong with that? Huh? What's wrong with that? Want clear to close? What the hell's clear? By the way, what the hell is clear to close? It's not a defined term in the contract or under the law. It's a made-up thing. And clear to close from one lender is different than clear to close than the other one. Stop using that term. We're ready, approved, or not. Okay, why don't you like that? What do you want from me? What proof do you want? What do you want? Or have your mother say, what do you want? What do you want? What do you want?
What would be considered proof to you? Pre-approval letter?
A pre-approval letter.
The approval letter.
Oh, you want the approval letter? Sorry, not going to give it to you. Not giving it to you. Is that okay? Yes. I have complied with the contract. I have given a written notice, not a copy of the approval letter, written notice of such approval. Well, we no longer use the word loan commitment, it's loan approval, because the lenders changed the form. So this is the flaw in the contract. And then if she says to me, well, who's the lender? None of your business. My client is very private. Okay, and you're right, you can't call me in default. I am in compliance with the contract. So we've cured that problem. All right, so in your packet, I gave you this language. This is what I suggest you use, whether you're the buyer or the seller. Even if you're the buyer, you should still do this. Because if you're the buyer, why should you use this? What happens if your buyer's smart and just says to you, tell the other agent I'm approved, and you as the buyer's agent goes, I want to see the approval, and your buyer says, it's none of your business. You as the buyer's agent have no right to it. So in your packet, I gave you some sample addendums. Use this always. Buyer shall provide written verification from the mortgage broker or lender of the loan approval in accordance with the terms set forth in this contract. I want it in accordance with the terms because I want it to say the interest rate and the term and the amount to make sure it complies. If buyer fails to obtain loan approval within the time set forth and hereby terminates the contract, buyer shall provide written verification of same and the reason for the denial. Why do I want to know the reason? There's certain buyers. We're in the Trump era. We're in the lying era. We're in the deceit era. Because you know what people are doing now? They sabotage their own loans to get out of it. Lying is, today's society is, yeah, it's the thing to do. Comes from the top. So, alternate truth. What truth is not the truth? The truth is the truth when it says loan denied, borrower failed to submit tax returns. Now, if it says that, and I had that happen, the buyer's not entitled to their deposit and seller gets to keep it because they didn't abide by the contract to apply in good faith and cooperate to do it. So you want to know the reason why. The reason why? The buyer went and bought a new car yesterday. Well, they didn't, they sabotaged their own loan. So this is why you want this language. And let me tell you, your seller, their first question is going to be is, wait a minute, we had that pre-approval letter, which is worthless. And how could they not get approved? He's a doctor, he's a lawyer, he's whatever. How could he not get approved? I don't know. Great realtor. I don't know. I get somebody else to sell my house. All right. But if you go, oh, I got this thing here, I'm going to get it for you. And the other agent goes, I'm not giving it to you. Oh yeah, the addendum had it in there. Let's see it. Yeah. All right. So please use this. Huh? No. Nope. Don't mark through anything. All right. Some sample stuff that I've seen. Seller will order inspection ASAP. Great. All furnishings to be included, interior and exterior. And if you're doing that, list them out. There will be a fight. Someone will take something. Seller to pay $3,900 towards buyer's closing costs. What's missing? Including prepaids, right? These are all actual ones, folks. I don't make this up. Date of closing, 5/7. However, buyer and seller both agree to close earlier once we are clear to close. That term that's not defined and no one knows what it is. This is a VA approved loan. Full price offer is contingent upon property appraising at the asking price. Otherwise, price will be appraised home value. This is actual. Ring, ring. Hey, Barry. We wrote the contract for 200. It came in at 180. Man, you're lucky because that's horrible. What if it came in at 220? If it came in at 220, your buyer would probably say, write me a check for 20 grand. Luckily, it came in 180. They also had in the contract that the seller was going to pay 3% of the closing costs. She called me up and said, hey, Barry, you got to help me out here. Came in, it was 200 purchase price, came in at 180. The seller said no. So I called up the agent and said, hey, look, we'll go ahead and waive the 3% closing costs if you'll go ahead and do it at the 180. I said, did you get your buyer's permission in writing to do this? I didn't even talk to him about it. I said, you just violated the law. You're subject to having your license yanked. You just volunteered to give away 3%. Well, what's wrong with that? I want the deal. I need the commission. You need to suspend your license. So I said, you better right now send an email to that agent and say, I'm sorry, I was mistaken. That was just discussions on my behalf. I had no authority to do that. I have, however, contacted my client and they insist that you abide by the terms of the contract, and we will be at closing on November 12th, and we will purchase the property for $180,000. We will get the 3% concession, and if you do not, my buyer has already consulted their attorney, and we will sue you for specific performance. She goes, what? I just emailed it to you. Send that. November 12th, 180, 3%, very happy buyers, not very happy sellers. Okay? Again, come on, folks. Oh, this has just got this is just way too much, but this is all kinds of crazy things in here. They get crazier and crazier. Oh, this is my favorite. Buyers of partially disabled veterans using 100% financing. You know, if you didn't have that, the contract wouldn't be legal. Buyer requests a copy of this. Buyer requests a copy of the seller's disclosure for his home. Request denied. I'm not giving it to you. Request denied. What happens if the seller comes back and goes, request denied? Nothing they can do about it. By the way, I had one time where they put in there, buyer requests the seller leave the John Deere lawnmower, come into closing, and the buyer's late, huffing and puffing, and she's all upset. The lawnmower's not there in that big yard, and the seller was a retired lieutenant colonel. Just looked right at the buyer and said, ma'am, request denied. The buyer's agent bought him a lawnmower. Yep. Buyer and seller agreed to extend closing date if necessary to complete the VA contract. Then the listing agent added in, this extension only pertains to additional time required by the lender. I said, Joey, are you crazy? Ring, ring. Hi, seller. Got some good news and bad news for you. This is a loan officer. First of all, thank you so much for selling your house to our veteran. Seller says, well, thank him for his service. Hey, but what got the good news is, hey, the buyer's approved. The bad news is, before you went into the service, you went to UCF and racked up all kinds of student loan debt. And he's going to have his right DTI in November of 2019. So the good news, he's approved. The bad news is we're going to have to extend it until November 2019. Can you imagine having to tell your seller? Woo! And the next one is no contract's viable without this. Buyers have already given bank statements and tax returns to their lender to make sure the processing of this loan is handled as fast as possible. Come on, guys. What are you putting in here? You got nothing else to do? All right, let's talk about the big one. We all know that OUC is called the reliable one. All right, they ain't so reliable. They spend lots of money branding and they do a good job on it. But these aren't good folks. And this is, I'm not making stance one or the other. They have some serious allegations. Generally, OUC is a pretty good utility company compared to them. They're a quasi-governmental, controlled by the city. They do a lot of good things, but this is scary. And what I'm saying right now is these are simply allegations made in a class action lawsuit. I don't know whether they're true or false. They're allegations. So in any lawsuit, until the jury rules, they're simply that, allegations, whether they're true or not. There's some scary stuff in here. The question is, if you're selling in the area affected by the class action, do you need to disclose this? My legal opinion is absolute yes. If you don't, you as an agent could face liability, your broker could, and definitely the seller. As I always say, disclose, disclose, disclose. It's better to disclose instead of not disclosing. Let's just play this real quick.
Located within a 3,200-acre environmental preserve in southeast Orange County, the Stanton Energy Center is a clean, modern, fuel-diverse, environmentally sound power generation facility that functions as the literal heartbeat of OUC. Permitted to generate up to 2,000 megawatts, Stanton solidifies OUC's reputation as the reliable one and underscores our commitment to be sustainable.
Okay. Okay, fast it up a little, David, so I don't have to listen to it again.
OUC's reputation as the reliable one and underscores our commitment to be sustainable too. Majority owned and operated by OUC, the Stanton Energy Center keeps our community's economic engines humming and our lights shining bright. It also provides reliable power to our partner cities, from Panama City to Key West. Commercial operation at Stanton began in 1987 with the opening of Unit 1, followed 9 years later by Stanton 2. These coal-fired power stations consistently exceed federal and state operating requirements through the deployment of state-of-the-art technology and environmental controls. Over the years, the Stanton Energy Center has expanded, in keeping with industry trends, by adding 2 natural gas combined cycle units, a landfill gas facility, and 2 solar farms.
Okay, so what's the problem? Let's go ahead and stop it. So here's what the problem is. The class action suit was filed. They have announced previously that, that's a PR piece, but they have announced before that they were intend to close this facility. Now, the gas and the solar, obviously, there's not an issue. The coal is. I don't care what anyone says. There's no such thing as clean coal. That's like saying there's clean emissions that come out of a car. There's ones at different levels. So the allegations here is from the lawsuit is it's coal combustible residuals of coal dust, harmful organic compounds. Some of this stuff I can't even pronounce. Radoncules, metals blowing from the plant. So what you need to know is, and what they're alleging is the results are pediatric central nervous system, blood and bone cancer rates that exceed the national and Orange County levels. They're suing Lennar, U.S. Homes, Avalon Park Group, as well as Mr. Colley, who is the developer. What they're saying is there was unacceptable, this is all from the complaint, unacceptable risks of contracting cancer and other disease. Children in the class area have been stricken with cancer and some have died. It also involves Stony Brook and Eastwood. There's things in here like what they're saying is even though promo said they in compliance with the regulations, the lawsuit says they're not. It says that there's metals such as copper concentration that are way above the federal cleanup level. Says that children are more vulnerable to the exposure. The class is within 32825 and 32828. It also infects, as I said, Avalon, Stony Brook, Eastwood, Cypress Springs, Andover Lakes / K, and Turnberry Point K. It says there's approximately 30,000 residents and 15,000 homes that are affected. They're saying that the cancer incident ratio, CIR, is 5 to 10 times higher than the average incidence in Orange County and the United States. They say this has been connected to leukemia, lymphoma, melanoma. They're saying that the copper, lead, cadmium, mercury, and arsenic levels are higher than the averages. I also did some separate research and did confirm that there's other studies that say those carcinogens are much higher that are coming out of that plant. Here's the big thing. This is why you need to disclose. There's count 2, inverse condemnation against USA. Condemnation. I got my property, they want to widen the road, they condemn it to take my land to build the road. This is what they call inverse condemnation, meaning it's against my will, I'm getting my property taken from me. And basically, if I lived in that area, I'm saying, wait a minute, who's going to want to buy this property because of what you guys did? So you have basically condemned my property by what you've done. So one of the counts in there says inverse condemnation is a cause of action against a government defendant to recover the value of the property which has been taken, in fact, by the government defendant, even though no formal exercise or power of eminent domain has been attempted by the taking agency. So what they said is OUC has taken, in fact, the property of the plaintiffs in the class, discharging pollutants and hazardous substances into and upon the land or water in the class area. So they want just compensation. Now, if someone does buy in there and says, well, I don't really care, or I understand the notice, I'm doing it, I want to do it. Now, what would happen years, this is going to take years, by the way. So say years down the road, the jury does come back and say that, what would happen is OUC would have to buy everyone's property. Now, there could be settlements on this. There could be a cleanup. The federal government could get in it. And that's all up in the air because this administration is cutting EPA down to the bones. There may not be money for cleanups. I mean, there's brown zones. Everyone might remember years ago, the Sentinel polluted for years, and it drained all the way down from the Sentinel down to Lake Ivanhoe. And Lake Ivanhoe was unswimmable. You had to stay out of it. It was so bad. Lake Highland couldn't use it. The federal government came in and declared that a brown zone, which is tremendous because there was millions, tens of millions of dollars used to clean up that area. All those apartments over there in the Nora district, the only reason they're there is because of the cleanup. Otherwise, they wouldn't be allowed to build there. Now, will one day, if these allegations are true, they could go in there and have a system to clean it up and it could become safe again. I don't know. It could be, I don't think it's another Love Canal, which was 30, 40 years ago where a nuclear power plant leaked. But who knows what's going to happen there? We don't know. All right. So in your Let me get a copy in there. In your packets, we gave you two different things. Is it in here? Huh? So there's two things you need to do, because this is what you're going to be faced with. First off, oh, and by the way, don't forget that if you're leasing property in this area, you must also disclose this to your tenant, because God forbid you rent to a family and they have kids and that kid gets cancer and they allege it's because of this, you as the landlord could be liable. So you've got to do it. So there's two things we put in here. One is an acknowledgement and authorization to disclose. So this is when you do your listing, you should have, my suggestion is you have the seller sign this that authorizes you to disclose. Now, what happens if a seller says, you're all transactional agents by law, so you have to. What happens if your seller says to you, you know something? They say they're smart. I want you to become a single agent and you're not to disclose this. Say, okay? Yes, sir. Okay, my opinion is no. You have a duty of good dealing, and I would say you should decline the listing. So have them sign this acknowledgement. Then we have a landlord disclosure for the landlord tenant in there. And then the last one on there is the seller's disclosure. So basically it's just a notice to seller, and it says Florida law requires of a seller of a home to disclose to the buyer all known facts that materially affect the value of the property being sold and that are not readily observable. That's right out of Johnson v. Davis case. This disclosure is designed to help you comply with the law. However, this disclosure form may not address every significant issue that is unique to the property. You should consider what you would want to know if you were buying the property. So then it's a notice to the buyer. And that's basically saying this disclosure is not a guarantee or warranty of any kind. It's not a substitute for inspections, warranties, professional advice you wish to obtain. It's not a substitute for your own personal judgment or common sense. The following information is based upon seller's actual knowledge of the property condition. A seller can disclose only what they actually know. Seller may not know all the material or significant items. You should have an independent professional inspection of the home, including but not limited to the structure, mechanical items, environmental, and legal title to verify the condition of the property and determine the costs of repairs and impact. And then it says on December 20th, a complaint was filed in the 9th Judicial Circuit. The name of the suit, it says the lawsuit asserts allegations against various defendants concerning alleged contamination and potential adverse health effects. A class area approximately 5.5 miles in radius from the Stanton Energy Center as defined in the lawsuit, resulting from airborne coal, dust, and combustion residuals, organic compounds, radionuclides, and metals. At this time, no determination has been made as to the veracity or truthfulness of the allegations in the lawsuit. Moreover, no determination has been whether said property falls in the class area. So that way, you're covering yourself and you're knowing it's out there. You're going to get some kickback on this, but folks, this is just a reality of life in that area right now. It is. There's no, I mean, I've heard other attorneys say, no, you don't need to disclose because you don't know whether it affects your property or not. You want to take that risk, go and do it. You're crazy.
Mr. Miller, just a quick question. Do we disclose this to just 32825 and 32828?
I think you need to make a determination and look at that radius chart and see what's in there. I would say if it's any of those subdivisions named in the class action or close to them. First of all, it's any class in the subdivisions, absolutely. If your property's not in a subdivision, but it borders them or within that 5.5, absolutely.
Class action says those two zip codes.
I'm sorry?
Those two zip codes.
Yes.
32825.
Yes, it has those.
Is it safe to just do those?
Yes. If you have those zip codes or those subdivisions, absolutely. And then use some common sense. If you're near any of those, listen, has anyone ever been sued for disclosing too much? No. So better safe than sorry. Throw it out there. I had one agent that said, I'm using this everywhere. I don't really care. Well, listen, you never know. There's lots of nuts out there. Let's say have someone on the north side of Colonial, right around the Alfea area. He's like, I'm not taking the chance. How do I know that stuff hasn't blown a little bit farther up? How do I know they're not going to increase the class area? You don't. But right now there's no allegations there. So I would say if you're not within the area, you don't really have to. But he's like, it's too close for me. I don't want to take the risk. I said, well, that's okay. Okay. The other thing I just wanted to make sure you guys know in the packet, because it's our new one, is the one for repairs. And I want to make sure, because one of the biggest problems is, it's a few back in there, addendum. It's the one with the chart. And the reason why I just did this one recently, because I've been getting a lot of feedback that when repairs are needed, they go do the repairs and they're like, they got a call after closing. Oh, they did the repairs and the thing's broken again. Really? 4 days after closing? Well, I say, well, what's your warranty? What warranty? You didn't get a warranty? No. So this takes care of it. So it says in here, seller at seller's cost and expense shall make the following repairs, replacements, or modification. Check 1, blank days of the addendum or blank days prior to closing. If the repairs set forth herein are to be completed less than 5 days prior to closing, the closing date shall be extended, because you need enough time in there. So you'll list them out, what room, what it is. But then it says, buyer shall perform the above referenced repair only utilizing duly licensed and insured contractors, licensees, or repairmen. Seller shall notify buyer in writing upon completion of all the repairs. I don't want it in bits and pieces. I want it all. All repairs completed herein shall be warranted in writing for 1 year for the benefit of the buyer. Buyer shall have 5 days from the date of written notice to the inspection, notice to inspect the repairs, and if buyer determines in buyer's sole discretion the repairs are not completed to buyer's satisfaction, the buyer may terminate this contract by giving written notice. If so terminated, then of course you get the deposit back. Now, if you're on the seller side, the seller may say, well, that's a little bit too harsh. Well, it could be. It's just a suggestion of what can be done. But some people may say, well, I don't want you to do a 1 year. You can change it to 6 months or whatever it is, but you should get it. Now, obviously, some things are not going to be warrantable, and that you might put a little asterisk, say warranty doesn't apply. If I fix the screen or something. But for things that aren't, because I keep getting calls, especially with pools. Oh, they fixed the pool. Yep, but it's leaking again, or it's this and that. I called the company that did it, and they said, oh, sorry, we'll charge you again to come out. Well, I said, didn't you get a warranty? No, I forgot to ask for one. Right? So this will have that in there. All right. Two last things. One is, if we didn't have it in the packet, but we can get them for you. One of the things I don't like about the industry is everyone's doing this gotcha, right? Especially on calendaring. We've designed a timeline sheet that has every single time requirement in the FAR contract. So if you're the buyer or the seller, I highly recommend, once you get your contract accepted, fill it out, send it to the other side, and say, I've gone ahead so we can have a smooth transaction of putting all the benchmark dates. Please confirm and reply that you agree with the dates. Now, they may say, no, you're a day off. Then you can discuss it. Because again, the effective date is not the date when the last person signs. It's when it's delivered. So that you may be a day off. That's the gotcha. So we don't want that. So if you don't have that, we'd be glad to provide it for you. Other thing too is we've got the cards here for all the classes, the whole year. Take advantage of it. We love doing them. Anytime you have a suggestion for additional other topics, please let them know. Sometimes we do some add-ons depending on some issues that come up. We will be following this lawsuit anytime something comes up on it. If you're on our listserv, we'll be sending up updates periodically when anything happens. So, because this thing is very, very important. All right. It's a firm out of West Palm Beach. Oh, I didn't even know. Where did here it is. Oh, just so you know, here's the area that's on here that it shows the map on. It's a 5.5 mile radius. Okay. Oh. All right, if anyone has any questions on there, I'll stay and ask questions from there. One last thing. First of all, thank you all for coming. This was the record number that we've had today because it's such an important topic. Try to come every month. We appreciate that. Those of you guys that do business with us, thank you. We appreciate it. Those of you that don't, we'd like to do business with you and talk to you about it, of how we can help you. We're really realtor centric. And one other thing that we do is a lot of places do their holiday parties in December. We do a client appreciation party that I'd like to invite you all to. That's going to be on the 23rd at Trade Bambine, right down the street. It's going to be the first ones in there. If you need any information on it, you can contact Meredith on there because we'd like to go out. Huh? Yeah. Oh, it is. It's today.
Can you put the map back up?
Yeah. Lake Nona is over here. Personally, if I was an agent, I would, it's, huh? Wedgefield, yeah, well, Eastwood. But, you know what we're going to do is we'll go ahead, over the next few days, we're going to post on our website. We'll post the map and we'll put all the disclosures on there. So if you want to pull them off or get that on there, I'll also go ahead and post the lawsuit in case that way, if any of your sellers want it, you can just pick the PDF right off there. Okay. So David, let's talk with Daryl about getting that done. So that way we'll have it on our website on there. So again, try to do that. All right. So, whoops, questions.
Hey,
What
Barry,
is
this is
between a lease
Park.
purchase and a rent to own? Lease purchase is you purchase it. Rent to own is more towards money going towards there. There's not a lot of distinction. It depends on some of the terms on there. We don't use the term rent to own. That kind of like, rent a center, you buy the TV and rent to own it. No, we don't do those. We do lease purchase or lease options. Yes.
You said because I didn't draft it, but I did help facilitate it. You said you had a form
For
lease purchase.
Yes.
You had one for you. Who do I contact you with that?
Contact Christian or Meredith can get it to you. Yeah.
What was the question that you had? What was the
For
question?
what? Yeah.
Yeah. What's the question you have?
The question is, what?
No. So the question is, they have a cash deal, but the buyer's now considering doing a loan. You're the buyer? Do you need to disclose it? No. In the FAR bar, if you check the box that says cash, it says it's cash. It says, however, the buyer may obtain financing. However, this contract's not contingent, so you don't have to.
Hey, Barry, can you hear us
Okay.
in Winter
No, they
Park?
don't. Yeah, so they don't have to. So the question is, if you check the box appraisal, for cash, you can still do financing. Yes. Daryl, your question?
Yeah, Barry, can you hear us?
Yes.
If a tenant is in an existing property out in that Avalon Park area, is the landlord required to notify that tenant about this lawsuit?
Okay, so good question. If you have a tenant in the affected area, do you have an obligation to go let your tenant know? You already got a tenant in there. By the way, let me introduce Robert Garcia. He's another attorney. Robert, come on up here. What do you think?
So there's a tenant already in the property in East Orlando?
Yeah.
Do you have a duty to disclose now? I would say yes. Yeah.
Again, here's the thing, guys. If you don't disclose, and then 6 months from now, ring, ring, hey, we're leaving. My kid's got pediatric cancer, and then I've just found out, and you didn't tell me, I'm gonna sue you. So if you disclose now, they may say, we're getting out. Now, here's the more interesting question after that. What happens now if they say, okay, now that you've told me this, I'm terminating, I'm leaving. Under Chapter 83, I'm giving you a 7-day letter that this is a hazardous condition. Now, that's going to be an interesting question. So now if they say, I'm going to terminate because of this, I think a judge would probably say, no, you can't. Why? These are merely allegations. They haven't been proven. Now, what I would say as the tenant's attorney is, look at these studies. Forget about the lawsuit. How about this federal report that says that the carcinogens are way above the federal level already? I don't need a lawsuit for that. Here's a federal report that's it. Then the judge might go, well, I don't know. So, yep, I would disclose it now. And if they want out, you gotta play that card of whether you want to do it or not. Yeah.
I should have close with the property in Avalon Park.
Sorry, say it again.
We closed on the property in Avalon Park, so now I'm scared.
Well,
When did you close?
Like 3 days ago.
no.
Well, the lawsuit was published on December 20, so it became public record at that time.
Right. So the excuse there is it was a matter of public record, but
It's always going to be fact specific, case to case. I think for the most part, you're going to be fine. What you're going to see is a trend. You're going to probably see, it's interesting to see the market stats about the number of
But
properties in
shouldn't the
East Orlando.
listing agent disclose that or how?
in my opinion, yeah.
Yeah.
As soon as that lawsuit was filed, they should have sent a disclosure. Yep. If you have something pending right now in that area, I would disclose it before closing. Your buyer may walk, but
Correct.
I have listings now in Eastwood, so I have to disclose that.
yep, you better disclose it.
Because what
Use that
happens, they're not
disclosure.
only going to sue the sellers of the home, they're going to sue you. And the law says,
And your
also like
broker.
seller's disclosure. The courts have held that duty has also extended to you guys as well as the realtors. So if you have a listing in Eastwood, I would just have your buyer, your seller, sign that acknowledgement form, that
So
disclosure.
I can use it or I can email you to get a copy of that or what?
What's in the package?
It's already in the
Yeah,
package right
it's in
now.
I
there.
can scan it and use it.
Yeah,
Yep.
sure, yeah.
Because what
By the
it
way-
does is it protects you.
Yeah,
from being sued.
but by the way,
So
folks,
I have a listing, rental, I have a tenant just moved by the beginning of December.
yeah,
Before
give them the addendum to sign.
Exactly. We drafted those to protect you guys.
Right. And by the way, all of our addendums in there, you're free to use. I know there's other firms in town that charge to use them, or they charge a monthly fee or things like that. I don't do that. That's not what we're about. We're about helping you grow your business and all that. So this stuff you can use. Now, of course, you come in here, you want us to do something for 3 or 4 hours of time, we don't give it away for that. But things like that, we don't. And if you keep seeing recurring things like for addendums, let us know. We like to do them, put them out, like that repair one. I just was starting to get call after call after call, and I'm like, you know something, let me just do this so everyone can use it, publish it out there, because we're a big, big believer in education. The way that our industry, whether it's title, attorneys, or realtors, becomes better for the public, they have confidence in us as a connected profession, is cooperating with each other, being the same team. Remember, you don't turn on each other, don't turn on your vendors. We're all a team and a cooperative to do that. And that's why it's all about the customer experience, because look, you can advertise all you want. I'm a firm believer in this. But if you give good service from the listing to the closing to everything, they're going to tell 10 people and they're going to tell 20 people. And that's how you grow your business. Good service, good vendors, you associate and make that a good experience. And that's why you got to work as a team. Look, nobody's perfect either. We all make mistakes, whether you do, I do, whatever it is, the lender does, but don't turn on each other. Work to make it right and just move on and keep it good.